Oh, yes. On belief, and in response to the question that my Lord asked shortly before lunch, it is, of course, also important to note that each individual seeking protection under the Equality Act must satisfy the elements of the Granger test in respect of their own belief. Yes. So they must establish that they have a genuine belief. They must establish the way in which the belief impacts on their life is cogent, coherent, etc. A belief in the abstract is not sufficient. And so we must focus on the specific individual, including, of course, in this case, the claimant.
Yes.
Now, with those broad principles in mind, paragraphs 34 on through to 39 of my submission, I identify four specific deficiencies in respect of the ET's reasoning. And I don't propose to rehearse the full contents, but in brief, the Tribunal's analysis in my submission confuses cogency and importance.
While you're doing this, can we
Yes.
have the Tribunal
We can indeed.
decision in front of us,
Yes,
and then you can say which
one-
paragraphs make the mistakes?
That would be rather helpful, I'm sure. 116. Cogency, one might think, is an unusual concept in the context of belief. Because if it's meant to be capable of rational persuasion, that rather undermines the point of many beliefs in the first place. See Williamson, the belief in the supernatural, the element of the supernatural. What's really significant in my submission is that the belief is mindful of the modest threshold requirement approach, to some extent intelligible and capable of being understood. That's the language that Mr. Justice Langstaff adopted in Harron. Cogency is not the same as importance. And so it's difficult to see in my submission how a belief which is reflected in various national and international provisions is a belief which lacks cogency, or a belief which lacks seriousness. Secondly, the Tribunal's adoption of a spectrum of possibilities, or range of levels, is, in my submission, contrary to the breadth of Article 9 itself. A belief may be held in private, need not be shared in a community. One need not be an evangelist or a proselytizer to be covered. And so the spectrum between the lobbyist or the campaigner and someone who professes to hold their beliefs on a quieter level is in an apt spectrum. To the extent that that spectrum assists, thirdly, it's difficult to see where the claimant was placed on it and on what basis. Because when we see 5.7.1, we broadly accepted her evidence on the issue. That evidence included paragraphs 4.8 and 4.9 of the judgment, page 112. I became passionate about my belief in the right of an individual, not only to aim but to profit from and receive credit for their own work if they wished. In order to explore these ideas further, I wrote a feature film screenplay in 2010 which explored issues of ownership of intellectual property. So to the extent that an element of proselytizing may point towards greater cogency or greater significance, it's difficult to see why writing about the issue would not be relevant. And then 4.9, I hope that the court will see that there is in this case an issue of deeply held belief of spiritual practice, of identity of human rights, and of the attempted colonisation of those private areas of person's life and mind by a commercial enterprise with no actual interest in that individual's work or devotions, or poems, or hymns, or life. Again, difficult to see why such a belief, which was expressed over some years, was, in the words of the tribunal, not sufficiently cohesive to form any cogent philosophical belief system. It's certainly beyond the immediate clause.
You say that the tribunal accepted that 4.9 is a statement of the belief.
Yeah.
Where do we find that?
Well, what we have at 5.7.1 we accepted that the belief was genuinely held in the sense that the claimant honestly believed it. The respondent had attempted to challenge her veracity in that respect, but we broadly accepted her evidence on that issue. Now, part of the evidence that she puts forward is under the subheading, the claimant's stated philosophical beliefs earlier in the judgment.
And at 4.10, the introductory sentence is, she may have held those views privately.
Yes.
So there's an exception.
There's a tacit finding in my submission that those were the beliefs, but she held them privately.
Oh, yes, but we go back to the discussion we had at about 12:10, which is what is the belief as found by the tribunal? And I thought we were agreed that it was 3.2 as pleaded, and as amended, or you would say
Read alongside.
clarified, 5.5. But it seems to me quite different to go further and talk about attempted colonisation by employers.
Well, it'll come as no surprise, my lord, to say that I respectfully disagree. The
Are
tribunal,
you saying that the tribunal find that was her belief?
the tribunal find, with the tacit opener of 4.10, read alongside 5.7.1, we broadly accepted her evidence. The aspects set out at 4.8 and 4.9 are part of the colour of the same belief. And I repeat the point with perhaps some emphasis. The opening sentence of the passage of 4.8 makes it clear that there's no disconnect. I became passionate about my belief in the right of an individual not only to own, but to profit from and receive credit for their own work if they wished. And an individual who cares deeply about ownership of their creative works, it is not acting contrary to that belief if they decide to work for a particular employer. They are receiving credit from their creative works.
Yes. All right, but I think the point my lord is putting to you, to express it in my own words, is that when we see the tribunal talking about the belief not being sufficiently cohesive to form any cogent philosophical belief system, we have to read that in the context where the tribunal has held in 5.5 that there is this very important qualification or clarification, however you wish to put it, of the appellant's belief. And so her belief is not that in all circumstances authors should own the copyright in their works. On the contrary, it is a belief that they should own the copyright in their works, except when produced on behalf of an employer. And so is not what the tribunal is saying, perhaps they don't use these words, but it is not the thinking that that's not cohesive.
My lord, that in my submission puts some strain on the tribunal's judgment. They deal with cohesion and cogency in some detail at 5.7.4. That's not the point that they are making there in my submission. It is difficult in the extreme to reconcile the notion that the claimant did not uphold the belief as some form of philosophical touchstone, with the evidence it broadly accepted, albeit the claimant did not communicate that expressly, that we see at 4.8 and 4.9. I mean, take for example, does the novelist say, who decides not to publish a particular work or their diary because they profess a fierce possession of that particular work, undermine their belief in that right of ownership by selling other work? The basic point is that an individual is at liberty to choose what they do with their creative output, mindful of the recognition as a matter of statute, and indeed in this case contract, that if someone is embarking upon a commercial enterprise, there's an element of forfeiture. There is no inconsistency whatsoever in my respectful submission between the claimant's belief as set out at 4.8 and the tribunal's observations at 5.5. And it is not the observations at 5.5 which preclude cogency or coherence at 5.7.4. What I would add, my lady, my lords, is this, that in considerable respects, the EAT concurred with the concerns the claimant advanced below. If we take paragraph 40, at page 67. I should say, claimant fully recognises that the EAT reached the same conclusion, but through a rather different route. As per Mr. Milsom's second point, namely that the tribunal may not have had the agreed formulation of the claimant's belief in mind when conducting its analysis, based on the range of levels of cogency and seriousness, would appear to have some merit. Repeated reference to copyright theft was a bad thing. That may be contrasted with the way in which the claimant put her belief, which was that it was a belief in the statutory human or moral right to own the copyright and moral rights of her own creative works and output. That may be said to be somewhat broader than simply an objection to copyright theft. The claimant's evidence also refers to the importance of writing in her life, which she claimed amounted to a spiritual practice. In those circumstances, the commercial disadvantage of copyright theft might be said to be only one of the several disadvantages experienced by the claimant in losing control of her work. I promise I will come back to paragraph 41, but paragraph 42 reference to the spectrum of cogency point in Article 9, and a recognition by the tribunal that a belief that is manifested only in private may be just as cogent, seriousness and coherent as a belief that manifests itself more publicly, although outward manifestation may be evidence of cogency and coherence. And again, emphasis on the manifestation issue. And then paragraph 44.
We'll no doubt come to the EAT judgment, but Mr. Miller, all I'm saying about your attempt to bring paragraph 4.9 into the definition of the belief is this, that I'm not generally much in favour of pleading points in employment law, but I think if you're bringing a discrimination case based on religious or philosophical belief, it has to be defined at the outset of the hearing before the tribunal what the belief is. And you and your appellant and the tribunal defined it as in 3.2.
I should say, forgive me, my lord, not me.
Sorry, not you.
I wasn't there, I promise.
Can't remember who was acting, but anyway, Kat said, not your fault. But
I'm not blaming anybody, but I wasn't there.
The representatives on both sides and the tribunal.
Well, the claimant's in person.
Okay, right. The claimant, the respondent's representative, and the tribunal pin it down at 3.2. and it's very important it should be pinned down. And you can take it either 3.2 as amended or elucidated by 5.5. But it seems to me that it's difficult if you then try to change it into something else. And 4.9 seems to me, at any rate, to be a much more aggressive statement of a claimant's position than 3.2 or 3.2 as amended by 5.5 or as clarified by 5.5.
My Lord, it may come as no surprise that the claimant's submission is that there is no inconsistency between those paragraphs.
Okay.
I'm prepared for 3.2 and 5.5 to be read of a piece.
Yeah.
And I still maintain, and 4.9, etc., is dealing with the strength of feeling as demonstrated over an intensity of that belief as demonstrated over several years of the belief in 3.9 and 5.5. My primary point is that there's no qualifier there, there's no exception there, it is of a piece with what the claimant was saying throughout. Even if there is some element of inconsistency, it's still amply crossed the threshold of those modest threshold requirements set out in Williamson. So even if you're against me on there being some element of inconsistency, it still crosses that threshold. And what the tribunal is broadly accepting in the evidence of a belief which it accepted the claimant held, albeit held privately, is the intensity of feeling that the claimant genuinely had.
Yes,
and acted
well,
upon it.
as we discussed this morning, you rightly pointed out that there's never been any challenge to her good faith, to her sincerity. It's always been accepted that she sincerely held these views.
Yes.
But the debate we're on at the moment is about cogency, or perhaps, as you rightly point out, coherence would be a better word. And isn't it important that the foundation for the tribunal's assessment of this question was what it said in 5.5 and 5.6? Because, as you point out, the tribunal accepted her evidence that she held these beliefs, but it makes the important point that in fact the belief that she held was not as unequivocal as her pleaded case suggested. On the contrary, it was subject to this rather important exceptional clarification, however you wish to put it. And the problem that the tribunal is identifying is that once you apply that exceptional clarification, then the belief ceases to be coherent. And it brings us back to the point we discussed at the outset this morning, that the dispute between the parties was about wording. It wasn't about the basic proposition as to ownership of copyright. It was about the breadth of the wording.
Well, and the implications of the wording. It's not simply a semantic exercise. Clearly the respondent insisted on the wording because it was intended to mean something. But I do maintain, I think, two methods. One, that is not the way in which the tribunal approached the question of cogency, seriousness, cohesion and importance, as the EAT accepted, subject to the manifestation point. And two, it would be a peculiar state of affairs if an individual were better protected under the Equality Act for failing to recognise the delineation in copyright law than they would be if they were acting in accordance with that statutory provision, with that statutory regime. The 1988 Act draws a delineation between work created in the course of employment and work that is not created in the course of employment, but I would say may relate to employment, maybe during the period of service, but not in the course of employment. that delineation is of such a significance that Parliament has intervened to legislate for it. The claimant genuinely, sincerely, and steadfastly believes in that delineation. Paragraph 44 of the EAT's decision page 70 puts it in the following terms. 5.7.4. There, the tribunal states that it accepted the claimant strongly believing in the right of ownership to her own creative output. Notably, the tribunal was not here describing her belief as merely an objection to copyright theft, but that it did not accept that she had held that belief as any sort of philosophical touchstone to her life. If by that the tribunal considered that the belief had to be one that affected all or many aspects of the claimant's life in order to qualify, then that would have been an error, as it would have amounted to setting the bar too high. It's quite clear that a belief in a single issue, which affects perhaps only a single but important aspect of a person's life, could qualify for protection. It then goes on to say that it's not what the tribunal meant, by stating the question is whether there was a manifestation of a belief through an act or omission, as opposed to such act or omission merely being motivated by a belief. In the present case, given the terms of the stated belief and the fact the claimant was being required to sign the agreement, the manifestation of that belief would axiomatically be in raising it as a reason for refusing to sign. She did not do so. Now, this is where we come in my submission to the EAT's approach.
Could I ask you one more question on this topic, and then I will try and desist. One of the differences between the wordings proposed by the parties was that the appellant's wording included the words during her contracted hours. I may not be quoting precisely, but therefore one way of illustrating the debate is this. Let's focus purely on the question of contracted hours. And let's just say that the respondent takes the position that in the Act, the words during the course of employment extend to work that is done outside contracted hours. And the appellant says, I disagree with that. So that is really a disagreement about the meaning of the Act. In other words, it's a disagreement as to what is the law. Is it your submission that that disagreement as to what is the law amounts to a philosophical belief which is protected by the regulations?
No.
Well, once you've accepted that, what's left of your case?
Well, the belief is as stated by the claimant. That the works created during the course of employment may belong to the employer, but there is a private sphere, and there should not be any unjustified infringement into that private sphere. Now, a disagreement as to the law may be an illustration of that belief in practice, but it is not the belief itself.
The disagreement as to what is the private sphere, as a convenient shorthand for work done not in the course of employment,
is an illustration of the belief, but it is not the belief itself. The belief itself is the belief that the tribunal concluded was genuinely held, was worthy of respect in a democratic society, related to a grave and weighty matter, etc. That's the belief. And what we're dealing with is the impact of that agreement on the belief. This is not simply about wording in the abstract, because that wouldn't sensibly be reconciled with the approach that the tribunal took in broadly accepting the claimant's evidence as to her earlier demonstrations and possession of that belief. My lady, my lords, I say, looking at paragraphs 40, 42 and 44 of the EAT's decision, the EAT would have upheld the claimant's appeal, but for one important point, which is the role of manifestation. Paragraph 29 first of the EAT's decision, or 27 first, page 61, cites Williamson. But when questions of manifestation arise, as they usually do in this case, a belief must satisfy some modest objective minimum requirements. And then they're set out. And it said that at paragraph 28, a scenario whereby claimant professes a profound belief but seeks to apply it in a haphazard, arbitrary or random fashion, such that the belief does not have any measure of cogency or coherence. But repeats the point, paragraph 29, the bar should not be set too high. And then at paragraph 31 considers Arrowsmith, to which we'll turn, but the point made there, an act which is motivated by a belief is not necessarily a manifestation of it.
And you agree with that?
A mere motivation is not in and of itself. I mean, yes. What's necessary to cross the threshold may perhaps need to be revisited following a reader in the Strasbourg courts, but motivation may not of itself amount to manifestation.
I think it had to be intimately linked, or I can't remember the exact word.
Intimately linked.
Intimately linked. So if it's not intimately linked, it's not a manifestation.
Yes. Yes. Then, but rather surprisingly, we have paragraph 31, just before that passage. This is the sentence I want to emphasise. Those criteria, the objective minimum criteria, are therefore to be applied to the manifestation of the belief, not to the belief itself. That's perhaps surprising given the citation of Williamson in paragraph 27.
And again, you're taking a microscope to Mr. Justice Chowdhury's judgment, whereas if we take a microscope anywhere, it should be to the EET's judgment.
The point that I make 2 points, my lord, which is absent the EAT's approach to manifestation, we say that the EAT was right to conclude, as it rather perhaps tentatively did, that the tribunal erred in its approach. I say, reading 40, 42 and 44, the EAT shared some sympathies with the belief ground of appeal, and it was right to do so. But the second point I make is this. Irrespective of what my lady and my lords conclude in this case, we have the president of the EAT giving guidance on the manifestation question in belief cases. And in my submission, the approach to manifestation below is erroneous, and I ask this court to overturn it. And we'll see the implications of it as an illustration in the head note of the EAT decision.
Yes.
Paragraph 33. The question, therefore, is whether doing an act or not doing it amounts to a direct expression of the belief concerned, and whether it's intimately linked to it. and the point is made in paragraph 34 that where there's no expression of the belief, it would be open to the tribunal to conclude that the belief was unintelligible and lacking a certain level of cogency or coherence. We then go to paragraph 41. The focus must be on the manifestation by reference to the act or omission in question. That's the first line of paragraph 41. And then finally paragraph 44 by F. In the present case, given the terms of the stated belief and the fact that the claimant was being required to sign the agreement, the manifestation of that belief would axiomatically be in raising it as a reason for refusing to sign. She did not do so. And on that basis, the tribunal, the EAT concluded in paragraphs 45 onwards that the belief, by focus on the manifestation issue, could not cross the threshold.
Does the last sentence of paragraph 44 of the EAT derive from a finding by the ET? Her objection was because of the difficulty it might create for her in seeking to sell her private water.
The impression she gave to her employer,
Yes.
I believe it does. Well, you have the passage from Miss Wilkinson's statement, I believe, or Miss Hayward's statement that I took you to before lunch. Where does the EAT's approach leave the law? Well, we have the head note of the ICR report, which I hope you have. Yeah, my lords. It's point 1. Held dismissing the appeal, that to qualify as a philosophical belief under section 10.2, the belief had to attain the same threshold level of cogency, seriousness, cohesion, and importance as a religious belief. The proper approach to whether the required threshold level be attained was to ensure that the bar was not set too high, since it was not for the court to judge the validity of such beliefs. And here's the crux of it, that simply in focusing on the manifestation of a philosophical belief, the same threshold requirements applied, and whether or not doing a particular act amounted to a direct expression of the belief concerned and was intimately linked to it was a question to be determined on the facts of each case. And although the claimant's refusal to sign an agreement might have been dictated by her stated beliefs, she had not made that known to the company, and accordingly the tribunal was right to conclude that the belief was not sufficiently cohesive to form any cogent philosophical belief, so as to achieve protection under the Act. This focus on manifestation or the elevated role of manifestation in my submission is a new approach, as the EAT accepted when granting leave, and the reasons it provided at page 85 of the court bundle. Belief complaints have been considered by previous presidents of the EAT, including Mr. Justice Langstaff and then Lord Justice Underhill in Maestri. And this focus has not hitherto been the way in which points are being put forward. Because if it is to become a requirement that there is a direct and expression of the belief at the time of acting or refusing to act in an indirect discrimination complaint, that risks importing a knowledge requirement to indirect discrimination complaints. And there's 3 points I'll make, if I may. Firstly, even in the Strasbourg context, the Article 9 context, the criterion applies not to the manifestation, but to the belief itself. Williamson, tab 2, paragraphs 23 and 76. I'm conscious of the time, so I'll give you the references. Aweda tab 8,
Sorry,
paragraph
just
82.
Just
and
go back to,
I'm conscious of the problem.
slow down, Mr. Milson. Williamson, tab 2, paragraph.
Paragraph 23, I'm conscious
Yes.
you don't have tabs. But it's page. I'm grateful, I think my genius provided the page numbers. Yes, pages 29 to 30 of the bundle, authorities bundle from Williamson.
Right. Aweda.
And Aweda, paragraph 82.
This is Aweda at Strasbourg, not Aweda.
Aweda at Strasbourg.
Yes.
Secondly, the EAT, to coin the phrase, has set the bar too high. In suggesting that the manifestation would axiomatically be in raising it as a reason for refusing to sign, that is something of a departure from the approach hitherto adopted. Williamson, paragraph 23, is a passage I've taken you to previously. Depending on the subject matter, individuals cannot always be expected to express themselves with cogency or precision. And what we know, the true test now is that in Aweda, and I will ask you to turn this up if I may, tab 8, page 133.
Starts at page 133 of the bundle.
It does. And it's the passage from paragraph 79, page 146 onwards. And the central part of the reasoning is at paragraph 82. Even where the belief in question attains the required level of cogency and importance, it cannot be said that every act which is in some way inspired, motivated, or influenced by it constitutes a manifestation of the belief. Thus, for example, acts or omissions which do not directly express the belief concerned or which are only remotely connected to a precept of faith fall outside the protection of Article 9. In order to count as a manifestation within the meaning of Article 9, the act in question must be intimately linked to the religion or belief. An example would be an act of worship or devotion which forms part of the practice of a religion or belief in a generally recognised form. However, the manifestation of religion or belief is not limited to such acts. The existence of a sufficiently close and direct nexus, and that's really the test, between the act and the underlying belief must be determined on the facts of each case. In particular, there's no requirement on the applicant to establish that he or she acted in fulfilment of a duty mandated by the religion in question. It's from that passage, incidentally, that this court concluded in Umber that the group disadvantage requirement that we see in indirect discrimination complaints is not a feature of Article 9.
Well, we'll come to Umber, but that's a different point.
It is, but whilst I'm...
At the moment we're on manifestation.
We are.
Do you say no manifestation is required?
I don't believe I am saying that. I'm saying the test is a sufficiently close and direct nexus between the act and the underlying belief. Now, the decision on which the EAT relied was Arrowsmith. In Arrowsmith, the belief was pacifism, and you have the decision now in front of you.
Sorry, I'm thinking aloud. Tell me if I'm wrong. Aren't we talking about manifestation in two different senses? In Aweda, Ms. Aweda was worked for British Airways. She wanted to wear a crucifix around her neck, visibly. The question is whether that was a manifestation of Christian belief in, if you like, the theological sense.
Yes.
It's not whether British Airways knew what the belief was. Of course they did. She was saying, I want to wear a crucifix to work, and there's a dispute about it which went on several years. I don't see why anything said about manifestation in that sense helps you on the question of whether it was necessary that the employers in this case should have been aware that in refusing to sign the form, Ms. Gray was manifesting her philosophical belief.
Well,
There are two different uses of the word manifestation.
my lord, there is no knowledge requirement for indirect discrimination complaints.
So, right, so
I mean, consider the alternative context of a hidden mental health condition. An employer may be entirely oblivious to that condition. A PCP may nonetheless affect that individual to their detriment, and subject to the disadvantage test, liability is, and justification, liability is made out. There is no knowledge requirement for any of the
knowledge
protected.
may be a feature of justification, though. in
Quite
that
so.
situation.
Quite so.
But so what are you saying? I'm struggling to understand what you are saying about manifestation. How, my lord asked you, how does it help you here to take us to paragraph 82 of A. Wader? And I'm just struggling to understand what you are saying about that.
What I'm saying, my lady, is really this. The test is sufficiently close direct nexus.
The test in Article 9.
In Article 9.
But we're not concerned with Article 9. This is a private employer with a private employee, and Article 9 doesn't really feature, does it? Or,
The Equality Act is informed by Article 9,
Yeah,
and
but-
the EAT's approach was informed by Article 9 below.
so what are you saying in relation to section, you've abandoned direct discrimination, indirect discrimination and the statutory.
May I turn my back for a moment? Yes. I mean, the first point I'm making is that the criterion of Granger apply to the belief and not to the manifestation. The second point that I'm making is if there is to be any role for manifestation, it's the Awada test of a direct and sufficiently close nexus. And that does not require, as the EAT suggests in its reasoning, a direct expression or a formulation of the belief. The question is, assuming that the other aspects of the belief threshold had been crossed, was the claimant in refusing to sign this agreement manifesting a belief?
So was she doing something that had a close and direct nexus between
Quite so.
with her underlying belief?
Yes.
And it might be said against you that she didn't, because her belief is, as you accepted, at 3.2 and 5.5, whereas what she's doing here is disagreeing about what the law about the private sphere means.
Well, the dispute, as it were, is whether the terms that the claimant was being asked to sign went beyond the course of employment, whether it encroached into that privacy.
There's a disagreement about what the law says about the words in the course of your employment, or your contracted hours, or the private sphere. Either way you want to put it.
Yes, I mean,
It's a disagreement about what the law, the reach of the law in this context. And that is not an act that is closely and directly linked to her belief necessarily.
Well,
indeed, I think the tribunal found that it wasn't, because they said they couldn't imagine hypothetical individuals with her belief who would go so far as to refuse to sign that agreement.
well, they do say at 5.15 that the claimant had been put to that disadvantage.
Well, she's been put to a disadvantage in being required to sign an agreement and being dismissed. That's the disadvantage, isn't it?
Well, the disadvantage in our submission is the crisis of conscience that is faced. I mean, this assumes that one gets through the belief threshold, but if she's got that far, the disadvantage is, as Her Honour Judge Eadie explored in Pendleton, the crisis of conscience that those who have the belief would experience, whereas others would not. The basic point I make is that the causation type questions of manifestation should play a limited, if any role, when considering whether the belief threshold is satisfied. The equivalent of manifestation in the Equality Act is to consider whether this is a case of direct or indirect discrimination. The manifestation question has limited, if any, role to play into whether somebody has a belief that passes the Section 9 test in the first place.
Yes, but we're on to manifestation. We've spent some time on belief. So you say that knowledge by the employer isn't a requirement of indirect discrimination. As applied to belief case, that seems to me very difficult. And there are cases about, say, I think it's the very recent case, a care worker, a worker in a care home, local authority care home, is a Sabbatarian Christian, regards it as sinful to work on Sunday. Would it be your case that an employee working in a care home could say, I refuse to work on Sundays, and the employers, without asking why, say, in that case we'll have to dismiss you? And she brings a tribunal claim saying, I didn't tell them this, the reason why, it's a fundamental feature of my Christian faith that I believe it to be wrong to work on Sundays. It might well be that the employers would be regarded as behaving outrageously if they knew and nevertheless said, you've got to work on Sunday or we'll sack you, and there'll be all kinds of issues about justification and so on. But how could the employers be criticised if she doesn't tell them?
Well, the basic point I make, my lord, is this, that there is no knowledge requirement at the liability stage subject to justification for an indirect discrimination case. Parliament could have legislated in the same way as it did in reasonable adjustments for actual or constructive knowledge being a prerequisite of liability. It did not. It is no different in a religious case, a religious or belief case, to a concealed mental health condition for the purposes of indirect discrimination.
Are there cases in which an undisclosed religious or philosophical belief has been the subject of a successful claim?
I'm not aware of any either way. So I'm not sure how far, with respect, that takes the deliberation. But it is a fundamental feature of indirect discrimination that there is no knowledge requirement. May have a real role to play in justification, no question. The other point I would make is that it was clear by September, some 9 months after the claimant started, that there were disagreements in principle as to the signing of this clause. That they may not have been enunciated by a belief that was as particularised as it was before the tribunal.
Well, they didn't disclose any crisis of conscience, as you described it. They were simply disagreements about the law and how the law applied.
The position of the claimant was, when faced with the ultimatum, sign this or be dismissed, in a job that she had been, on the basis of appraisals, competently performing, no questions whatsoever, I will have to be dismissed.
Yes, because she had a film or a book or whatever she wanted to do, and she was worried that she might lose the rights to it. But that's got nothing to do with a belief.
Well, it is an aspect of the belief in
well,
my
you
submission.
say that, but on another view, it's got nothing to do with the belief, because her belief is that the Copyright Act applies and that Section 11, subsection 2 applies to mean that the employer is the first owner. I might have got the sections wrong or the subsections wrong. But
You're there or
the
thereabouts,
first
I think, my lady.
11.2.
It is.
Yes. Her belief is that there should be no unjustified colonisation, as she put in the evidence the tribunal broadly accepted, by an employer or anybody else into the private sphere. And those matters created in the course of employment were not in the private sphere. That is the delineation that she firmly believed.
All right.
Certainly at the threshold stage of whether a belief crosses the threshold, the approach of the EAT that there need be an enunciation in order for the belief to be protected is deeply problematic in my submission. Let's take the example of an individual refusing a conscription order on the grounds of concealed Quakerism. Need the individual state, I cannot serve because I am a Quaker, or would it be sufficient if they simply refused to serve?
Conscription.
Conscription.
Well, that would bring Article 9 into play.
Well,
it would be an emanation of the state, and we're in a very different sphere, aren't we?
Well, what I'm really saying there is that direct expression of a belief or a formulation of the belief is not a prerequisite to whether the belief crosses the Equality Act threshold in the first place. I mean, part of the reason that I'm spending some time on this is because the EAT itself relied upon a lot of Article 9 cases, including Arrowsmith. Arrowsmith concerned an individual who who professed to be a pacifist, and sent various missives to British soldiers. And I'd ask the court to consider paragraph 72 of Arrowsmith.
Yes.
Yes. So this was a leaflet that was sent by a professed pacifist, which included the following section. I'm not against being a soldier. I would be willing to fight to defend this country against an invader. I'd be willing to fight for a cause I could believe in. But what is happening in Ireland is all wrong. And there the Strasbourg court concluded that it could not be found that the leaflet conveys the idea that one should under no circumstances secure political or other objectives by violent means. What we know, however, from cases on manifestation, such as Claimant, where an individual refused to serve on the grounds of pacifism, that there's been very little focus indeed on what is said at the time that an act or omission takes place. In other words, the insistence that the belief be formulated in some form to accompany what we say is the true manifestation of the belief, i.e. the refusal to sign the agreement, does not feature in the Strasbourg court decisions at all. The third and final point I'd make on the manifestation issue is that this court is, of course, looking at this through the structure of the Equality Act.
Yeah.
The state has a duty to protect Article 9 rights, even in private employment, and we see that from OEDA. But it is made clear through the explanatory notes and elsewhere that the manifestation question may be relevant to whether there's indirect or direct discrimination. It is categorically not relevant to whether there is a belief in the first place. And indeed, it would be difficult to make sense of previous decisions were this, the approach of the EAT in this case, correct, not least Maestri. Maestri concerned a professed or attempted direct discrimination complaint in relation to a belief in the higher purpose of public sector broadcasting. The belief was not communicated to the employer. Now, if
let's just have a look at least at the head note of
well,
the Maestri.
unfortunately, it's a transcript of a permission decision, which of course comes with the caveats, but it says
Yes,
so.
well, since you referred to it.
Of course, it's page 155. The reason I say that is that we don't have the don't have a head note.
Oh, I see. All right. Any decision of the Vice President is entitled to great respect. So let's have a look at it.
The belief is set out at paragraph 3 by the Tribunal, a genuine and strongly held belief in the higher purpose of public sector broadcasting. But the Tribunal also found that that belief had not been conveyed or expressed to the employer. Paragraph 13 refuses permission on that basis. I do not believe it's arguable that a generalised assumption that senior management employees will subscribe to BBC values can be equated with knowledge that a particular employee has a philosophical belief in those values. The fact that to the applicant those values constituted a belief with similar status and cogency to a religious belief does not mean that they will be so in every case. To others it would indeed be no more than their employer's mission statement. Now, if the EAT's approach is correct in this case, you don't even get there, because there needs to be some element of communication to the employer in order for the belief to be protected in the first place. And the point that I make, my lady, my lords, is that whatever outcome befalls this appeal, the role of manifestation has to be kept to its proper territory. That being on the causation question, group disadvantage in an indirect discrimination case, insofar as group disadvantage is necessary. But it is the belief where the focus must lie, and there is no knowledge requirement in an indirect discrimination case. Now, the Tribunal's analysis below on disadvantage and justification was to complete the picture, as it were. It was not central to its reasoning, since the Tribunal concluded the claimant did not have the threshold belief in the first case.
Yes.
I'm conscious that I do, of course, have to address you on those matters as well. The approach to group disadvantage is at page 118 of the core bundle. It's 5.13 through to 5.15. Tribunal has found, Tribunal found and the respondent agreed that the requirement to sign the copyright agreement was a PCP, and that the PCP put the claimant to disadvantage, but that there was no group disadvantage. The reasoning it gave is at page paragraph 5.14. That issue required us to consider whether other holders of the claimed religious belief would also have suffered the same disadvantage. Would they have refused to sign the agreement and been dismissed? That question could not safely have been answered in the claimant's favour, since there was no evidence that the clause would be reprehensible to all of those who shared the claimant's belief. People may not have viewed the restrictions imposed by the agreement in the same way that she had.
Sorry, which paragraph am I for?
5.14.
514.
Yeah.
Right, thank you. Yes.
Would have been reprehensible to all of those who shared the claimant's belief. Other people may not have viewed the restrictions imposed by the agreement in the same way that she had. The clause was not obviously unreasonable, nor did it obviously go beyond what was reasonably necessary, etc. The EAT expanded upon that analysis. There are a number of fundamental problems with it in my submission. First, are two features of the EAT's approach to indirect discrimination, which are respectfully incorrect.
No, all right. We'll come to the EAT in a moment, but we focus on whether the ET made an error or what is wrong with 5.14 before we get to Mr. Justice Chowdhury.
I'll bypass that point. The first point I'll make therefore is what is needed to show disadvantage. It was not necessary to show in my submission that others would not have signed. Simply that it would have impeded on a tenet of the belief. The reason I say that is to consider the following examples. Christians can, in theory, work on Sundays. Women who have childcare responsibilities can, and very often do, juggle those with a working environment. Disabled people may adopt coping strategies to muddle their way through particular PCPs. But to require those groups to do that which creates difficulties puts the protected class in a position of additional hardship. One need not show that coercion has been successful or that there has been some element of compliance. Instead, the focus for an indirect discrimination complaint is as set out in Homer, tab 6, page 105, and paragraphs 14 page 110. And the point Baroness Hale makes there is that the new form of the Equality Act was intended to do away with the need for statistical comparisons where no statistics might exist. It was intended to do away with the complexities involved in identifying those who could comply and those who could not, and how great that disparity had to be. Now all that is needed is a particular disadvantage when compared to other people who do not share the characteristic in question. And then at paragraph 17, page 111, the law of indirect discrimination is an attempt to level the playing field by subjecting to scrutiny requirements which look neutral on their face, but in reality work to the comparative disadvantage of people with a particular protected characteristic. Now, it's important to emphasise that. The focus of indirect discrimination is not to eliminate unjustified group discrimination, as the EAT put it in paragraph 60, but instead to level the playing field in respect of ostensibly neutral criteria. And there is no particular measurement required when considering whether there is particular disadvantage, provided there is some element of that disadvantage.
Well, what evidence was there of any element of disadvantage in this case? Were there people with crises of conscience who didn't want to sign but nonetheless did sign? Were there people who fell ill as a result of the requirement to sign, but nevertheless signed? What disadvantage do you say the claimant brought evidence of in relation to others in a hypothetically or actually similar circumstance to her?
Well, this is where we come to the case of Pendleton.
Well, just give me an answer to my question before you take us to another authority, please, Mr. Wilson.
The point I make, my lady, is this, that there is no need to produce evidence of a statistical or any other nature.
I'm not asking for statistical, I'm asking you, what evidence do you say there actually was? Maybe there wasn't a need for statistical evidence, maybe there wasn't a need to show 10 other people who refused to sign. What do you say the evidence was that showed that the claimant wasn't a sole adherent of her own idiosyncratic belief?
Well, the claimant did not put forward evidence
There was no
of
evidence
anyone
of
else.
of anybody having a crisis of conscience or feeling sick about having to sign but nonetheless signing.
No, there was no such evidence.
So that's really what the tribunal was saying. They weren't saying you have to refuse or you have to be prepared to resign. They were just saying there was no evidence of anybody else suffering any sort of crisis of conscience or anything in relation to this. You accept that?
I do. But what I would add to that is that if one considers Pendleton and the EAT, there is no need for any such evidence.
All right, well, let's look at Pendleton.
Pendleton concerned a Christian teacher, an Anglican, whose husband was a head teacher, accused of downloading indecent images of children and was imprisoned accordingly. She stood by her man, as it were, and refused to divorce and maintained her marital relationship with him. And she was dismissed for that. Her case was that because of the tenets of her belief, to require her to either disassociate with her husband or face dismissal was an indirectly discriminatory PCP. And the analysis of the EAT starts at page 237, analysis for the present purposes. Paragraph 31, this is tab 14. Arnold says this: I do not read particular disadvantage for these purposes as requiring any particular level or threshold of disadvantage. It seems to me that the term is apt to cover any disadvantage. So where a comparison is carried out to determine the existence of a particular disadvantage, care must be taken to ensure that the pool is populated by persons who are the same or not materially different. More generally, paragraph 32, in considering cases involving religion or belief, it's not a requirement that the ET determine whether the particular manifestation of the belief is a mandatory duty or requirement. The EAT continues to consider what the disadvantage in truth was here. And that's a paragraph 40 over the page. For some individuals falling into the comparator group, being in a partnership but not married, or married but not sharing the same view of marriage rights as the claimant, the disadvantage might have been the same as that suffered by the claimant. The task of the ET was, however, not to pick out particular individuals who might fall into a particular group, but to consider the potential groups, those sharing a protected characteristic and those not, and ask whether, taking as applicable to both the difficulty inherent in such circumstances for anyone in a loving and committed relationship, those who also held a religious belief in the particular sanctity of marriage arising from the sacrosanct nature of vows made before that God face a particular disadvantage. And the disadvantage, as the EAT saw it, was the crisis of conscience that individuals in that circumstance would face. And we see that paragraphs 41 onwards, and in particular paragraph 46, I'm simply recognising that in these circumstances, those sharing the claimant's belief would suffer a particular disadvantage given the crisis of conscience they would face. This was a case where the EAT confidently concluded, and we see this from paragraph 44, there could be only one answer to the disadvantage question. The EAT determined that answer without reference to any evidence of anybody else experiencing a similar disadvantage.
But it was possible in that case to say, based on religious beliefs in the sanctity of marriage and the sacrosanct nature of vows made before God, that people who were forced to choose between their husband and their job would have a crisis of conscience. In this case, the tribunal said, we can't safely say what other people who held the 3.2 plus 5.5 belief would make of this agreement, because it was pretty close to what the claimant herself was suggesting she would have been prepared to sign, and she was accepting the law of the land in the Copyright Act at section 11, subsection 2. So that they couldn't conceive of how a hypothetical individual would react, and that's your difficulty, isn't it? That's why there isn't perhaps a sufficiently close nexus, and that's why the tribunal couldn't imagine this hypothetical group of others who share the disadvantage. It's completely different from Pendleton with respect, isn't it?
What I say, my lady, is this, that the belief is, that the claimant professed to have, the tribunal found she held genuinely, was the moral and human right to own one's own creative works, subject to works created in the course of employment. When looking at the agreement, the original agreement, which is the agreement which must be the focus of the 16th of September meeting, the focus of this claim, what the agreement required was anyone signing it to take such steps as were desirable to surrender rights over works created not simply in the course of employment, but during the period of service. The natural and clear reading of those clauses in my submission goes beyond what the claimant perceived to be a justified intrusion of her belief. And the question that must be asked, and obviously we only get here if the claimant satisfies the belief threshold, whether those who profess the same belief, or whether a particular number of those who were in that circumstance faced a similar particular, or would face a similar particular disadvantage. Now that is a hypothetical question, without evidence of others in support of it. Just the same as Pendleton. Pendleton was a hypothetical question with no evidence of anyone having either been subject to the rule in the first place, or, particularly still, those of a similar faith. And of course, not everybody who was Christian would have the same approach towards the dilemma the claimant faced.
Wasn't the tribunal in Pendleton and the EAT on appeal effectively taking judicial notice of the fact that Miss Pendleton was not the only person in the entire country who took the view that marriage was sacrosanct? So they could take judicial notice of the fact that she was not the only person who believed in the sanctity of marriage. And therefore the question was one of straightforward conflict between, did she adhere to the sanctity of marriage, or did she give up her job?
Well, I come back to the point that I made earlier, which is in order to give effect to Article 9 through the Equality Act, as domestic authorities has repeatedly made clear one must do, there must be recognition of the particular sensitivities around minority beliefs, that they may not match the same regimented structure of certain other world faiths. What can be said in my submission is really this: would someone who had the same belief as the claimant, or was a group who had the same belief as the claimant, amongst that group, face the particular disadvantage of a crisis of conscience? And I say that in circumstances where the natural wording of the copyright agreement goes beyond the 1988 Act, the same notice could sensibly be given. Namely, that those who do not wish to surrender more than lawfully required of their own creative output would face the same dilemma. You need not establish, following Pendleton, that everybody would be facing the same circumstance. It may be that everybody else would have signed. The question is whether the particular disadvantage of the dilemma is a common feature.
I think you're saying it's sufficient that if she's the only person in the world who holds that belief.
Well, I'm not positively advancing the case that she is the only person in the world to hold that belief.
What my lord was asking is that sufficient to give rise to a case in law? So that, in other words, is the answer to can there be a belief with a sole adherent for present purposes? You say yes.
Yes, I do. Because we know from Article 9 that there is no need to establish group disadvantage for the purposes of an Article 9 claim. We know from Umber that there should be an attempt to give effect to that need for, or the absence of a need for group disadvantage. It's simply that in Umber, the approach taken by the Court of Appeal was that the requirement for group disadvantage could not be read down. Instead, it should play a role at the justification stage.
All right, well, we've put off looking at Umbar, but we've got
to that stage,
haven't we? So let's look at it now.
It's tab 10, page 173. Paragraph 34. The protection of freedom of religion conferred by that article does not require a claimant to establish any group disadvantage. The question is whether the interference of that individual right by the employer is proportionate given the legitimate aims of the employer. And the point is made in paragraph 35. Article 9 cannot be enforced directly in an employment tribunal. The Strasbourg Court of EU to appreciate that fact. The immediate decision in Strasbourg has not and could not affect the region's statutory jurisdiction, and therefore the claimant's Article 9 right is incapable of direct enforcement in the Employment Tribunal. However, domestic law must be read to be consistent with convention rights where possible in accordance with Section 3, HRA. In my judgment, it's simply not possible to read down the concept of indirect discrimination to ignore the need to establish group disadvantage, but I see no reason why the concept of justification should not be read compatibly with Article 9 where that provision is in play. In that context, it does not matter whether the claimant is disadvantaged along with others or not, and it cannot in any way weaken her case with respect to justification that her beliefs are not more widely shared or do not constitute a core belief of any particular religion. For this reason, the Employment Tribunal was wrong to make reference to that as a factor assisting the employer. So a large number of authorities which say that a belief, even if there is a sole adherent, may nonetheless be protected, and provided there is a close and direct nexus between the belief and the mistreatment or ill
Under
treatment.
Article 9.
Article 9.
Well, what do you say about the sentence from what you've just read beginning, in my judgment? It is simply not possible.
Well, the answer to that, my lord, and I don't seek to make points as to whether that's a ratio, etc., because the simple fact is the EAT in this case, in Trahorn and in Page, on which my learned friend relies, certainly treated it as the ratio, and that is the decision of Imber. What I do say, however, is this. The approach in Pendleton provides some practical answer to how that problem may be dealt with. Namely that there is a hypothetical exercise. And the question becomes, is there a sufficiently close and direct nexus between the act and the underlying belief? And if that PCP would put that group at a particular disadvantage, then that is sufficient. Indeed, the phrase would put is found in the recast directive as well, Article 2 of the recast directive. But there's perhaps a neater way to the same destination, which is the EU Charter. If this court...
Just pause. Are you saying that what Lord Justice Elias said in that sentence is wrong, incompatible with the EU Charter, overruled by something else?
Well, what I say is that there is a tension recognised by Lord Justice Elias and Umber between the Article 9 requirements, which must be given effect to pursuant to Section 3 of the Human Rights Act, and the requirement for group disadvantage and indirect discrimination claims. To the extent that Lord Justice Elias's conclusion that it is not possible to read down the group disadvantage requirement forms part of the ratio in the eyes of this court, then plainly I'm stuck with that when it comes to purpose of construction. This court can't overrule itself. But what I do say is that Lord Justice Elias's conclusions have been overtaken by events, the central event being the effect of the Charter.
Okay.
And it's important to take that in stages. Firstly, there can be no serious dispute that we're within the material scope of EU law. The Framework Directive, page 335, tab 24. Firstly, it expressly recognises the role of the Convention. 24.
Thank you.
Recitals 1 and 4. And then we have the concept of discrimination as defined in Article 2, 2b. Indirect discrimination should be taken to occur where an apparently neutral provision, criterion, or practice would put persons having a particular religion or belief at a particular disadvantage compared with other persons, subject to appropriate and necessary, etc. Section 19 of the Equality Act is the implementation of the recast directive.
Yep.
Secondly, we know that the principle of non-discrimination is a fundamental principle of EU law.
Yes.
And we have that from the decisions of Mangold and Helm, Kukudovici, etc. That authority, or that line of authority, is fully explained at paragraph 76 and 77 of this court's decision in Ben Carbouche.
Yes.
And indeed it continues paragraph 78. Therefore, we're within the material scope of the Charter. The Charter at page 343, tab 25. And in particular, Article 10, freedom of thought, conscience and religion, and Article 21, non-discrimination. As to the scope of the rights under the Charter, Article 52 is instructive, and Article 52(3), for obvious reasons, is where attention must lie. And so far as this Charter contains rights which correspond to rights guaranteed by the Convention for the Protection of Human Rights and Fundamental Freedoms, the meaning and scope of those rights should be the same as those laid down by the said Convention. I.e., there is no requirement in Article 9 for group disadvantage, and nor should there be on the proper implementation of the Charter to a fundamental principle of EU law, namely non-discrimination.
That's pretty simple. Lord Justice Elias, who was unaware of all this, is that
Well, the
both
Charter...
the Charter and the Framework Directive 2000.
Well, the full effects of the Charter had not been properly considered by the time of IMBA.
Yeah, well, it didn't become binding till the Lisbon Treaty in 2009.
Well, it certainly doesn't look like it was argued, for one. There's no reference to it. And certainly the first time in which the full effects of this application by reference to the Charter had been fully appreciated was in Ben Carbouche, which was 2016.
Yes. You just show us the paragraph in Ben Carbouche Court of Appeal, which
Yes.
we now have.
It is, it was tab 16. It's the passage between sideline or horizontal direct effect 76 through to 76, but it's really 76 through to 79. Given the parallels between the Convention and the material scope of EU law that Article 52(3) of the Charter make explicit, I would of course ask the Court to consider paragraph 79 of AWIDA, which emphasises just how fundamental freedom of conscience is.
AWIDA, not
paragraph 79 of AWIDA, where freedom of thought, conscience and religion is identified as one of the foundations of a democratic society. So the territory in which we're in, my lady, my lords, it is seen as fundamental both through the prism of the Convention and through the prism of EU law, as Kukudovici and Mangold make plain.
So your submission is that regardless of whether Lord Justice Elias was correct in his analysis with respect to Article 9 of the convention, the same cannot be true of the impact of Article 10 of the Charter.
Yes. There are two routes to the same destination. One is purpose of construction. The other, rather more extreme, is disapplication of any group disadvantage requirement. If this court is bound by UMBER when it comes to purpose of construction, the same cannot be said for the Charter. It's the first time that the effect of the Charter on the group disadvantage requirement, to my knowledge, has been considered.
But why isn't the availability of an avenue of challenge by reference to direct discrimination an answer to this point in relation to the Charter? The Article 9 and Article 10 don't distinguish between direct and indirect discrimination. That's a quirk of domestic law.
Article 9 and Article 10 of the...
Article 9 of the Convention and Article 10 of the Charter. The protection for freedom of religious belief or other beliefs.
Or non-discrimination in its Article 21 form.
Yeah. We've in domestic law, we give domestic protection for those, for that protected characteristic by protecting against unlawful direct discrimination, which has no requirement of group disadvantage, and where one can envisage that neutrally applied criteria, practices and provisions may affect more than one individual disproportionately or adversely, we give protection through indirect discrimination provisions. Why doesn't that satisfy our international obligations? Why do you have to strike down the group disadvantage requirement in indirect discrimination to do that?
Well, because two sides of perhaps the same coin. In direct discrimination, there is generally a knowledge requirement, and there is no justification defence available.
That works to the employer's disadvantage, not to the individual's protection of his or her rights. You're saying these domestic provisions don't give the same protection or adequate protection. The knowledge requirement and the justification, or the knowledge requirement might be, that the justification doesn't, non-availability of justification doesn't disadvantage the individual, it disadvantages the employer.
The point I'm making, my lady, is that there needs to be, if one accepts, as this court did in UMBER, that there is no group disadvantage requirement under Article 9, the effect of the Charter is such that there needs to be some home for cases where there is no need for direct disadvantage, but there is a direct and sufficiently close nexus for a link between the belief and the mistreatment complained of.
Direct discrimination?
Well, Madam, my lady, that would not cover all instances where there is a direct and sufficiently close connection between the belief and the mistreatment, precisely because of the knowledge requirement. Now, there are two ways of dealing with that lacuna. One is to read down the knowledge requirement in direct discrimination. The effect would be altogether more adverse for an employer, because cases where there may be instances where there may be no knowledge whatsoever as to the belief, let alone the disadvantage occasioned by the belief, would not be subject to a justification test or defence. The second is what we suggest, which is there is no reference to the need for a group on the face of the directive, nor indeed on the face of Section 19. Would put persons.
Others.
Others and persons. That is a difference
Well,
to more than one person.
Save that, unless a tribunal was satisfied that this was a case, completely satisfied that this was a case where there were no other adherents beyond the individual. I'm not saying that is this case. The question is whether the PCP would put such persons at a disadvantage. It is a hypothetical question.
It's would, if applied to the group is the 1,500 employees of the respondent.
Or indeed any applicant.
Or others who want to apply.
Yes.
So if applied, that's what would apply means. It doesn't necessarily mean hypothetical comparators, but I know you're arguing that hypothetical comparators are a permissible group to consider. But here you've got 1,500 individuals of the respondent and any number of potential applicants and others who, in respect of whom this PCP might have been applied, and no evidence you've accepted, whatever adduced by this claimant, that any of them suffered even a crisis of conscience in having to sign. That is no evidence of any single other person affected.
I'm bound by that.
Yes.
Yes. Yes, Ms. Barrett points out that discrimination as recognised in authorities such as Claimant includes not only treating like cases alike but different cases differently. The Convention recognises the existence of both direct and indirect discrimination as necessary parts of the same picture. And so in those circumstances, direct discrimination in my submission is not a sufficient answer to the group disadvantage problem, which Lord Justice Elias recognised in Umber. That's paragraph 44 in particular of Claimant. Treating like cases alike. Treating differently persons in analogous situations is not the only facet of the prohibition of discrimination there in Article 14. The right not to be discriminated against the enjoyment of the rights guaranteed in the Convention is also violated when states without an objective and reasonable justification fail to treat differently persons whose situations are significantly different. And of course,
why does that help us here?
well, the point I would make is this, that it would be difficult to conceive of a direct discrimination case. Let us assume that the claimant had a valid belief, or indeed in a more conventional case of religious days, Sundays being the obvious example in Christianity, but one can envisage a minority religion where there are specialised days or days of service. Dismissal for failure to turn up to work because of those days. That is never going to be the territory of a direct discrimination complaint. In this instance, it would never be a functioning direct discrimination case, a workable direct discrimination complaint, to say that the claimant refused to sign because of the belief, or she was dismissed because of her belief. She would not have been dismissed because of her belief. She would have been dismissed for refusing to sign the agreement. Right. So a direct discrimination complaint would never get off first base. And it's for that reason that the only way of dealing with the group disadvantage problem is through the prism of the indirect discrimination complaint. There may be a direct and close nexus in the Article 9 sense between the refusal to sign and the belief, but the dismissal would not be on the grounds of the belief, it would be on the grounds of the refusal to sign.
Well, that's what the tribunal found, but it's not what she argued. She argued it as a direct discrimination.
She argued it as both.
Yes. As did Ms. Wader, as did Ms. Ladil. It doesn't. the fact that they didn't succeed doesn't mean that it isn't possible to conceive of a way. If she had been right that this was a sufficiently close and direct manifestation of her belief, she may have been successful in establishing that the employer dismissed because of that manifestation. That would be direct discrimination.
I've not been. I must say, I'm not aware of any case in which that has ever succeeded. And the reason it would not succeed is, of course, that's not the operative reason for the employer behaving as they do.
Well, not generally. Yes.
Not generally. It would be pretty exceptional. And of course, there's much to be said in the evangelism scenario, which is the most obvious manifestation, to allow the employer room to advance a justification defence, as in Wastley and various other authorities. The best means, indeed the most workable means, of securing the true effect of Article 9, as one must, by reference to the Charter, is through indirect discrimination rather than direct.
All right, well, I think we've got the Charter point.
We have the Charter point.
We agree with it, but I think you've developed it. Are we on to ground 3 justification?
We are. The justification defence, or what's meant by the justification defence, we of course rely upon the judgment of Baroness Hale in Homer, tab 6, pages 112 to 113. I'm conscious of the time, so if I could ask the Lordships at a good moment to read through paragraphs 20 to 23. We of course rely upon a summary of the law there. The central matters are that the measure must be considered as appropriate to achieving a legitimate aim, and the discriminatory effects of it must not go any further than necessary. And there must be reference or consideration of the disadvantage caused by that measure. Here, by its own admission, and it's the phrase it adopts at paragraph 5.20, page 119 of the core bundle, the tribunal had not come as far as a detailed consideration of justification. And indeed, it would be superfluous for them to have done so, given their conclusions on the other matters. There were errors that may perhaps have been immaterial insofar as they got, but are perhaps more important on this ground, namely that there was only on one amendment, there were not two, and where the claimant was saying there was something very close in between her draft and the alternative document, that was close to the amendment, not the original.
Yes.
And so, if we get as far as this stage, the claimant contends that there can be little confidence in the tribunal's balancing exercise for justification. There are more fundamental problems, which is that, firstly, that the approach to the tribunal appears to put the focus on the claimant's arguments why it was not justified, rather than the converse. The burden rests firmly on a respondent's shoulders. But secondly, there was a failure to grasp the nature of the disadvantage, namely the crisis of conscience with the ultimatum of signing and infringing on that belief versus dismissal. And without consideration of that true disadvantage, the justification exercise could not be safely carried out. But thirdly, and most fundamentally, there was a need to take stock and consider the less discriminatory alternatives available. The aim relied upon by the respondent, 5.16, page 119 of the core bundle, is the protection of the respondent's own intellectual property.
Yeah.
The respondent expressly denied any interest in the creative works of the claimant produced outside the course of employment. We see that in the ET3, paragraph 7, page 133 of the core bundle for your note, and indeed paragraph 4.14 of the tribunal's judgment. No interest whatsoever in the claimant's personal work. In other words, the respondent's professed interest was confined to what was the position in statute, i.e. material produced in the course of employment. That was aptly protected, we say, by clause 13 of the contract, which the claimant duly signed.
That related to inventions.
And if anything else were required, and it referred to designs as well, my lady, it's inventions, improvements, or designs.
But not to copyright.
But not to copyright.
So how is it aptly protected?
If anything more were needed, the confinement was to material in the course of employment. A phrase which is used in the contract in clause 13, but for reasons which are unclear, not replicated in the agreement. The agreement refers to during your period of service. And in my submission, the natural effects of whichever version one looks at, but certainly the original, which was the version we say is critical for the purposes of conducting the justification balancing exercise. Material written or made by you alone during the period of your service would plainly cover material inspired perhaps by work, creative work inspired by daily employment, but not produced in the course of employment. And the respondent does not say it had any legitimate interest in material prepared or produced outside the course of employment.
Well, just a minute. Can we look at what the Employment Tribunal said in paragraph 5.18 of its decision? Because what they said in that paragraph was, if the claimant had written a play, a book, a poem, or a screenplay about anything other than the respondent or matters arising from her employment with the respondent, or matters which did not relate to any business of the respondent, we could not see how such work would have been caught. So, I don't understand to have been suggested before the EAT that that was a wrong conclusion as a matter of law.
Well, my lord, it was certainly suggested that the natural reading of the clause was to cover material produced outside the course of employment. Well, at least it could cover such material. I mean, 5.18, material arising from employment or relating to a business of the respondent would not necessarily be limited to material produced in the course of employment, whether that's a reference to working hours or outside of working hours. So there is an element of the devil being in the detail here, which is that even if the tribunal's right in that sentence, that is wider than in the course of employment.
But it comes back to a disagreement between the parties as to the scope of the words in the course of employment. And there is in fact a fair amount of case law on that subject, which obviously we've not gone into. But certainly I don't understand it to have been, any of that case law to have been put before the Employment Tribunal, nor was any argument mounted to the effect that the respondents' interpretation of Section 11, subsection 2 of the Copyright Act was untenable as a matter of law.
Well, no, it certainly was not developed at first instance along those lines, and nor is it developed along those lines here.
And so if we assume, as I think we must, that each party had an arguable view as to the law, why is the respondent not perfectly justified in saying, well, we've got at lowest an arguable position as to the law, certainly as a matter of UK law, and therefore we're entitled to insist upon it?
My lord, if that had been the position adopted by this employer, then there may well be a point to that, and respectfully a strong point. But the position is this: the respondent expressly eschewed any interest in creative material produced outside the course of employment. The wording of either version, and critically the original version, is wider than any interest the respondent professed to have. Or at the very least, the claimant was reasonably entitled to conclude that the wording was wider than any interest the respondent professed to have.
Well,
and so
you made the point earlier, and you gathered that I at least was not greatly impressed by it, that having suggested a less stringent wording, and your client refused, the employers cannot go back to the original wording because they have demonstrated that the original wording cannot be necessary. Well, supposing we're against you on that, and we have to focus on the amended version, you still say that that does not constitute justification because it at least arguably goes beyond what the respondents get anyway from section 11.2.
I don't put it in that way. I say it goes beyond what the respondent professed to be interested in. The legitimate aim, as ventilated before the tribunal, was the protection of its own intellectual property, expressly abandon any interest in material produced outside the course of employment. The wording of either version goes beyond that, and insofar as it goes beyond it, it relates to an interest the respondent professed not to have. Now, how in those circumstances could justification be made out?
Well, is that right, though? Because let's go back to the discussion we had before about contracted hours. So the respondent didn't accept your client's point of view that its rights were restricted to what was done in her contracted hours. And suppose, I mean, you can't say that was beyond its professed interest, was it?
No, if she was working at home on something that was plainly in the course of employment, then of course it would be covered by Section 11 as much as anything else.
Right. So the dispute between the parties is as to the ambit of the obligations.
Yes. That's not the. Can I turn my back? Yes, I mean, page 10 is the amended wording. Relating to any business, any matter arising from employment. Is the phrase used repeatedly. Now, that does go beyond the interest that the respondent asserts by reference to its legitimate aim here. Because it said, and the tribunal accepted, it had no legitimate interest in creative works which may be inspired by the workplace. Private works were not part of its concern.
Sorry, what does that mean?
Well, the point I really make is that a diary entry of a working day, or a novel inspired by colleagues at work, or a screenplay, or a poem, or whatever it might be, would relate to the business of Mulberry Company and or any matter arising from employment, namely your interaction with colleagues, but would not be in the course of employment. I do maintain, of course, that plainly it's relevant to the balancing exercise that a weaker version or a diluted version of the agreement was suggested. But the crux of the indirect discrimination complaint is the events of the 16th of September, by which time the amendment had been withdrawn.
Right.
A number of the points on justification I made at an earlier stage. The respondent did not insist on uniformity. And the ultimatum of signature or dismissal was first made clear on the 16th of September. I wish to pick up on a matter my lady raised, which is whether there is a causal connection between the ultimatum and the events of the 16th of September. Well, there is in part, of course, but it was the respondent's decision on the 16th of September to present the position as an ultimatum, not by reference to the amendment, but the original. Now, there may be some element of sympathy with that, but that is not the same as a causal link. It was the respondent's decision to present the ultimatum by reference to the original. That was not an inevitable consequence by any stretch of the claimant's position. And this was not a case in which the claimant did not engage. There were discussions as to the appropriate agreement. It is worth noting that the respondent's position is that the agreement was not suggested to be contractual, and that's page 50 of the supplemental bundle, the notes of the meeting. And it's also worth noting the section of Ms. Wilkinson's statement. We both wanted the same outcome. In those circumstances, my lady, my lords, the question is whether the original version, in requiring the claimant to take all steps as were desirable to substantiate the rights of any works written or made by you alone or with others during the periods of service, went further than necessary. The respondent does not seek to defend the natural implications of that clause. What the ET's analysis on justification was really fortified by 2 points. Enforceability, well, except there's no real decision on enforceability one way or the other, and the educative value of an agreement. That's 5.19. The second we say can go nowhere. This is the second aim, or second aspect of the aim. It made employees aware of the position that they were in terms of copyright law and legislation. That's a basis for an agreement. It's not a basis for the agreement or this agreement. What the tribunal had to do is consider, by reference to the material put forward by the respondent, whether that particular set of terms went further than reasonably necessary, and we say that it did. Can I turn my back for a moment?
Yes, of course.
Madam Lawrence, I've been somewhat longer than I anticipated. My apologies for that. There's a
Very patient.
lot of material to get through, of course.
We'll just we'll retire for a few minutes to consider where we go from here. In particular, whether we wish to hear Mr. Siddiq on everything, some things, nothing, and we'll come back and let you know. Thanks.
Tenacious. Really tenacious. That's what an advocate should be. Well done. Okay. I think I'm going to ask to come back tomorrow morning.
Yeah, for the moment. How long will it be?
It depends.
Surprise.
We would like to consider overnight all the points that Mr. Milsom has made, and Mr. Siddiq, I'm sure, will come tomorrow prepared to deal with everything, and we'll let you know whether we need you to deal with everything or just some points. So we'll say 10:30 tomorrow.
No problem, Uncle. Thank you.
Surprise.